Welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everyone in between. My name is Dan Balkaran, as you'll see on the screen shortly, and I'm an employment lawyer at Samfiru, Tumarkin, LLP. As always, Samfiru Tumarkin is Canada's leading employee-side employment law firm. Okay, so I am going to be answering all of your questions about all things employment law over the next 30 minutes. I encourage you all to get your questions in as soon as possible. I would like to try to get to all of them, if I can, before the end of the broadcast. And just a moment of housekeeping before we get started. If you need to get a hold of us, you can do so at employmentlaw.ca, help@employmentlaw.ca, and 1-855-821-5900. I apologize for that alarm noise in the background. That should be short-lived. There's just some alarm testing happening where I'm located at the moment. Okay, let's get started. Any questions we have? We only have a couple questions. If you could send all your questions in as soon as possible, that would really be helpful. Okay, question from Sir. I told my boss I was taking time off to attend a course on leadership. The treasurer found out and decided not to pay me. Can this be a constructive dismissal? Well, no. The short answer is no. So a constructive dismissal. So first of all, you are deciding to take an education course for your own education, which the company has not approached you about and not decided that, and has not said to you, hey, we're going to pay to send you to this class. Okay, you've just decided to take it on your own. And while that might make you a more valuable employee to your employer, there's no agreement from your employer to pay you for this time. And so really what you've done is you are requesting time off. And so you can choose to take that time as vacation or not be paid for it. Okay? There's no, if the employer is not going to agree to pay you for the time that you're away because it doesn't want to, or it doesn't see this as a valuable addition to your experience in education in the workplace, there's nothing you can do about that. The second question, in terms of, is this a constructive dismissal? So constructive dismissal is a misunderstood concept to the public at large. What it is where the actions of the employer are in effect a termination of your employment. So there's no explicit termination. It's the actions of the employer are a termination. And where a court would look at the actions and say, this person no longer works for this particular entity. And so there are two broad ways to get to constructive dismissal. One is where your employer changes a fundamental term of your employment that you reject. Okay, so classic example, your employer cuts your pay by 50%, cuts your hours by 50%. Sometimes demotions can be a constructive dismissal. You go from a senior manager just to an entry level employee, things like that. So it's the key to that branch of constructive dismissal is where there is a fundamental, or there's a change for the worse, not for the better, to a fundamental term of your employment, like pay. I said earlier, pay, demotion, hours, that kind of thing. Usually pay is what gets you there, but it has to be non-trivial. So in BC, it's different province to province maybe, but in BC there's a case that talks about up to 10% not going to be a constructive dismissal, 10 to 20% it'll be a constructive dismissal with something else. So it's a cut in pay and it's a loss of something else, be it prestige or position or what have you. And then above 20%, it's going to be a constructive dismissal. So it's a general rule of thumb. Here, there's actually, let me tell you about the second way to get to constructive dismissal. Second way to get to constructive dismissal is much harder, and that's where the actions of your employer are in effect a repudiation of the contract of employment. So if it looks like the employer just simply does not want, like it's trying to force you to quit, like it through its actions over and over again, it clearly just wants you to go away. That would be a constructive dismissal. But it's hard to get there, and you need a substantial amount of evidence, preferably evidence in writing. Those cases are challenging. In your case, there's this not paying a course that you elected to take voluntarily is not it's not a failure or a change to a fundamental term of your employment, and it's not really evidence of your employer no longer interested in being your employer. So on either front, this is not a constructive dismissal, and your solution here is to, if there is going to be one, which I don't think there will be, but if there is one, it's going to be figuring out some sort of amicable resolution with your employer that maybe it pays you for 50% of the time or something. Maybe you could make the argument to your employer that in fact, the value of this leadership course will reap a benefit to the employer, and therefore they should pay you for some of the time that you were at this course. But do you have a legal avenue of redress? No, you don't. Okay. Sorry, give me a sec here. Got a couple other questions. Okay, question from Giovanni. My employer is refusing to provide my record of employment after I was let go. Is there anything I can do to get this? Well, so they may not be, the legal requirement is that the record of employment is provided to Service Canada. And so quite often, and that's the legal requirement on the employer. So quite often what'll happen is the employer will refuse to provide or just simply not provide the record of employment to the terminated employee, but they will provide it to Service Canada. So before you go any farther, Giovanni, you should go to Service Canada's website, create an account, or unless you already have an account, in which case log into your account and see if your record of employment has been uploaded. If not, certainly you may wish to ask your former employer for a copy of it. If you've already done so and they're just not responding or not providing it to you, you can talk to Service Canada, and Service Canada can contact your former employer and force them to issue one. Okay, but the larger question, I think, for me is, why do you need your record of employment for purposes of EI? Sure, absolutely, and you should talk to Service Canada about that. If there's any other reason, I mean, records of employment don't really do anything other than they are for the government to be able to assess when your employment ended for purposes of EI, taxation, that kind of thing. But in terms of, do you need it to move on to find another job, you don't. So, but certainly if you're trying to get EI and you need that, and they're dragging their feet, try talking to your former employer, try logging into Service Canada, and if all else fails, tell Service Canada that your employer is not issuing you your record of employment, and Service Canada may be able to contact them and correct that, and at least initiate the process for moving you towards getting EI even without the record of employment. I think they issue one on their, I can't remember the process exactly, but Service Canada would be able to answer those questions. A few more now. Okay. Question from Pitt. My employer has a history of terminating people who make any complaints. I am dealing with workplace harassment and don't know what to do. I'm worried that if I say anything, I will be fired. Yeah, what should I do? Well, it depends who. I guess there's a lot of questions there. Who's the harassment coming from? Is it someone within the employer leadership team itself? Is it from someone farther down the leadership totem pole, the leadership tree? Is it what is the nature of the harassment? Is it objectively harassment, or do other people think that what you're experiencing is harassment, or is it something else? There's a large spectrum for harassment. There's all the way from sexual harassment, which is quite often usually objective, to my boss gets grumpy with me sometimes, and sometimes people think that's harassment. There's a whole spectrum in between. So if you're facing legitimate harassment, you can make, this is where the jurisdictions vary, and I have, you certainly want to look into it first. But there should be occupational health and safety legislation and a body in your province that can deal with complaints about safety, which includes harassment. And if you are legitimately being harassed, you can make such a complaint. Usually that government body will investigate, and then your employer cannot terminate you arising from your complaint about a threat to your safety. However, I will say, generally speaking, if you make a complaint to a government body, I don't see your employment lasting that long. Like the employers tend to look at that very poorly. They might wait 6 months, they might wait a year, and then figure out a way to get you out anyway. If it's a situation where it's not the leadership team, or there's an objective harassment, it may be that you can have a discussion with your employer to try to get it to stop. But these are tricky situations. How important is your job to you? Is it a situation where you're making 20% above what the market will pay you, and you've been there for 15 years and you got to stay no matter what? There are different factors in play. I would say for you, Pitt, this is an impossible question to deal with more than I've dealt with just now on a one paragraph question. So I would urge you to talk to an employment lawyer. If you need to do so, if you need to talk to us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Because all those questions matter. How objective is the harassment? Who is it coming from? How important is your job? What is your severance position? So for example, if this is legitimate harassment that you make a complaint about and are fired, maybe that's a good thing because you have 24 months of severance coming to you, and you might as well get it now before you move on to something else. Or it could be you're 63 and you need to make it to 65, and it's going to be very challenging for you to get a new job at 63. So, there are lots of different factors in play. But I appreciate that you're alive to the fact that your employer doesn't like receiving complaints and tends to terminate people who make them. While that is problematic under the law, certainly that will inform your strategy to a significant degree. So I encourage you strongly to talk to an employment lawyer. Okay, Ron asks, how binding are non-compete clauses? Is a great question. Does it differ depending on what industry you work in? Okay, so there are two types of restraint of trade clauses: non-compete clauses and non-solicitation clauses. Non-compete clauses in their core form say that employee cannot, after employee loses one's job, can't work for a competitive or similar employer for a prescribed period of time in a prescribed area. So, Ron can't work for a competitor in the widget making business for 12 months in North America, anywhere in North America. So that would be a typical non-compete clause. Non-solicitation clauses are they stop the departing employee from poaching former colleagues. Hey, I used to work with you, now I work over here. Leave your job and come work for us. So that's the first part of what it does, and then it stops you from poaching customers, and sometimes they try to stop you from poaching potential customers of your former employer. Okay, so the distinction is, obviously in what they are, there's a distinction, but non-compete clauses. So let's just say, Ron, all you know how to do is make widgets. You've been making widgets for 20 years. You have a mortgage and you have multiple children. Okay, it's a bad outcome for society if, because your contract says you can't compete, you can't make widgets for anybody else for a period of 12 months. Look at the outcomes to society. You might lose your house. It's very bad for your kids. If you can't put food on the table, these are terrible outcomes. And so, generally speaking, non-compete clauses are not going to be enforceable. And in order for them to be enforceable, they've got to be strictly circumscribed. So the geographical region has to be quite limited. North America is not going to do it. Canada's not going to do it. Even BC is probably not going to do it. It has to be strictly defined in terms of area. And then in terms of time frame, it has to be strictly defined. And even then, if you're just a regular employee, probably not going to be enforceable. If you're a senior vice president with knowledge of trade secrets of the business, that's different. But if you're, Joe widget maker, probably not enforceable. Okay, and so what ends up happening with a lot of them is that they get written down on interpretation to a non-solicitation clause. Non-solicitation clauses are presumptively enforceable. Okay, so non-solicitation, the idea, because that's really, it's completely understandable that the business would want to protect itself against you, the employee, and at that point, a former employee, from stealing their customers, stealing their staff. That's totally reasonable. And so, generally speaking, non-competes will be written down and interpreted as non-solicits, or just given no force and effect at all. Now, it can be that they are, in very rare instances, that the non-compete clauses are enforceable. If you have a real legitimate concern about that, you should talk to an employment lawyer. If you want to reach us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay. Hope that helped, Ron. I don't want to identify this person because it might give away who they are. So this person works for a major bank in a call center for 15 years. He's affected his mental health. Doctor asked for him to be accommodated in a back office role. I was given time to find a job internally for 3 months. I've applied for many jobs and I've qualified for, and no success. I'm wondering what options do I have as my 3 months will finish. Well, so you've been given a note saying you can't be on the phones, right? In a call center, that's basically what it is. So the obligation of the employer is to make reasonable efforts to accommodate you're federally regulated, but I assume the Canada human rights legislation is the same as provincial, to accommodate you to the point of undue hardship. So they're looking for a position for you and they can't find it. So if you're at the end of your, hold on. So I don't know what the 3 months is. I don't know that you're saying, is that when your medical leave ends, or your like I don't know if you can clarify that or not, but you can bring the note again to your employer and ask them for some sort of accommodation, or if you could be in the call center but not on the phones, like you can continue to look. Banks are going to try pretty hard to accommodate you, probably, but what happens at the end of the 3 months? It depends what the 3 months is a threshold time frame for. You may wish to extend your medical leave if your doctor will write you a note in that regard. I don't know what the medical challenges, and I'm not asking you to post it here, but you've got a lot of complicated pieces here that it's really going to be impossible for me to answer now. And so through this forum, reading 2 paragraphs. So you may wish to talk to an employment lawyer. These are, when you're talking about medical leaves and accommodations, these are real challenging situations. If you are on a permanent basis, for example, unable to do the core function of a call center job, it could be that your employer can claim that your employment has been frustrated and that it doesn't owe you a job or any severance. These are challenging. You want to make sure you get it right. I would talk to an employment lawyer to navigate all of this, thread the needle, as it were. Whatever solution you're going to find here, I think the best one is going to be an amicable solution. Okay, so something where the employer is content to put you in a role, and you're content to be in that role. That is not, frontline call center, if that's what the challenge is. If you do want to get a hold of us to talk to an employment lawyer here, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. But this one's challenging, and I certainly can't answer it more than I have based on the limited information I have. But I certainly would want to know what the 3 months is for, and intend to find a job internally for 3. I say they've given you 3 months to find a job, and then what? What happens at the end of the 3 months? Have they told you that? So I would talk to an employment lawyer. If you've got more information you can share, then please do so, and I might be able to circle back around to it later in this broadcast, although we're running out of time now. So what can you do if a coworker is, this is a new question, sorry. New question again, no identifiable name. What can you do if a coworker is making false claims against you in the workplace and damaging your reputation? Oh boy, that's a tough one. I found that most employees and almost every employer don't do this. There can be contention between employees over jobs. Certainly humans fight with each other in the workplace. Rivalries develop, all that kind of stuff. But false claims is a big one. How serious, it's hard to win in that situation, because if you don't deny it, then people think that you did it. And if you do deny it, you look like you're, doing your dirty laundry out in public. I would, depends on how good a relationship you have with your boss. If your boss is willing to go to bat for you, what's actually happening, the seriousness of the allegations, is this just a minor thing, or is this like someone's making an allegation of sexual assault or harassment or something, it's a complicated one. I don't think there's necessarily an employment law solution here, other than if someone claims that you are doing something that you have manifestly not done, and you complain about it to your employer and say, listen, I don't know what this person is talking about. I haven't done any of these things. And then the complaints the harassment, effectively, the false allegations continue, or your employer starts interrogating you about can you claim constructive dismissal at some point based on repudiation? Maybe. I think that's incredibly challenging. I think that I don't know very much about your situation here, but I think that your best bet usually there is an employer that's on your side and not on the side of the person who's defaming you. So I would. I don't even know if an employment lawyer can help you in this situation. You may wish to talk to one just to hear what they have to say about the specific facts. I certainly am not going to be able to assist beyond what I've just said. I do think probably the resolution is one between you and your employer, if a resolution is needed, but it just depends, right? Like, how severe are the allegations, and how long are they going on for? What your relationship is like with the company and your boss. Like, it's a challenging situation. If you need to talk to us, you certainly can. I'll give you the information at the end. Graham asks, can an employer, let's see how many questions we have, only a couple more. Okay. Can an employer fire you for expressing a political opinion that they disagree with? Got into an argument over politics with a boss and was sent home. Okay. All right. I'll say generally we live in politically fraught times. Okay. This is not the 1980s or 1990s where, we can respectfully disagree about items and then go have a beer afterwards together. Political items. Like, it's just not that. People are much more passionate about the current, about politics generally, be it global issues, be it domestic issues. And so I would say generally, both in your workplace and on social media, particularly on social media, I would stay away from any sort of political discussion, as no good can come from it generally, as you can see from what Graham has said here. Okay, so it's already happened. His question is, can they fire you for it? No, I mean, generally no. I don't know what it is in other provinces, but in BC, if you're a provincially regulated employer, sincerely held political beliefs, they have to be sincerely held. And often the test has to do with, the legal test has to do with that, which came about during the pandemic and mandatory vaccines and so forth. But no, you can't be fired without incurring human rights risk for holding a sincerely held political belief. Now, Human Rights Tribunal in British Columbia has a substantial backlog. Damages tend to be small, although there are lost wages damages. But I don't think it's a good outcome if you were to be fired over it. So the question is, can you salvage the situation, or do you want to? Maybe you do want to move on, and this is a way to get money on the way out the door. But can you salvage the situation? If that's something you want to do, maybe you go talk to your boss and say, listen, I'm sorry, I shouldn't. I have strong political views. I shouldn't discuss it in the workplace. I'm not going to. I pledge that I won't in the future. Keep it professional, et cetera, et cetera. Whatever it is that your boss wants to hear. That might be a good idea. And it might be a good idea to do it fast before your employer starts moving the ball down the road towards a termination. Generally speaking, employers aren't going to fire you, for having different political views, but each employer is different. Again, it's a risk for them, given they might not know this, right? They might not know that sincerely held political beliefs are protected. It also depends on what you said. There are. I think depending on what you said, it could be that, for example, the Human Rights Tribunal, or even a court, if you have a good severance claim arising from your termination, they may not be sympathetic towards you, depending on what was said. So, you've got to evaluate all of that and then decide what you want to do. You may, the safest play may be just to talk to your boss right away and say, hey, sorry, not going to do that again. Appreciate that people have different political views. But certainly, my views or I'll keep my views to myself and won't mention anything in the future, something like that. You may want to do that right away, but that's your decision, obviously. But do you have an avenue of redress in the event that they fire you? Yes, you should. Again, subject to each location. If you're provincially regulated, what is legislation, the human rights legislation in your province say? But generally, there should be some protection for sincerely held political beliefs, assuming that's what you had. Okay, we're almost done. Tim said, my employer forced me to take 2 sick days because I was wearing a sling at work. I have an injury from several years ago that flares up sometimes, and I did this to give it more support. It doesn't impact my ability to work at all. Can my employer force me to take sick leave for this and require me to provide a doctor's note to be able to return? I think it's probably reasonable for you to provide a doctor's note to return. I don't know what you do for a living. I don't know if it's physical or it's a desk job. But if you worked in a factory, for example, it's completely reasonable for your employer to send you home. It's completely reasonable for your employer to ask you for a doctor's note. If you work as in a desk job, less so. I do think generally, if this is happening and you didn't want to be sent home, and this is a sort of chronic and more in the nature of carpal tunnel, and they sent you home anyway after you explaining that, I think that there's a challenge then between you and your employer. That may be resolvable. It may not be, in terms of how you see and approach your employment there. Can they force you to get a medical note? What's the harm in getting a medical note? I would just get a medical note and that ends the situation. Are you going to get the 2 sick days back? No, but sick days aren't really that valuable. It's not really something that I would risk blowing up your employment for. I do, like I said, I think it's over something that where you're set. So for example, I had carpal tunnel many years ago, and I had a really thick wrist brace on my right hand for about 6 months, and then it went away. And if I was wearing that, my employer said, you got to get a doctor's note. And I said, no, this is just so I can type without pain. And then my employer sent me home, I would have some second thoughts about that particular employer. So, you're not seeing eye to eye. Is there a way for you to see eye to eye? I would think about that. But in this narrow moment, I think that, you're not happy that the they sent you home and you're not happy, they want a doctor's note. But I mean, that's not a reason to jeopardize your position and your strategic position, I'll just say, at your employer. I would go get the doctor's note, say, here's the doctor's note. I wear this from time to time. Doesn't impact my ability to work. And hopefully that ends the conversation. So, and at least it allows you to go back to work and continue to earn income. So I would just get the doctor's note. But yeah, I mean, is it reasonable? It might be. Depends on the nature of the injury. Depends on what you do for a living, factory versus desk job, that kind of thing. Okay, we're almost done, but this person who came back or said earlier that they required medical accommodations. They're given 3 months to look for a job, came back and said, 3 months is an internal job time. I've applied to many jobs and I'm qualified for no success. My doctor recommended back office role on a long-term basis. More it is that 3 months has come to an end with no success. When asked my manager what happened, she advised she will go back to her call center, that you will go back to your call center role. Well, it depends what your doctor's note says. So if your doctor's note says, no, you can't do that, well, if you can't work in a call center and your job is call center, it could be that your employment is frustrating. And so you may wish to get another doctor's note, reiterate and say, like, can you do more than just say to me that I can apply for these roles? Can you put me in a role? Like, why do I have to apply? I've worked here for X amount of years. You know me. Can you just put me in one of these roles? Right. But is your employer required to do that? I don't think so. I think that you work in a call center and now your doctor's saying you can't be on the phone. That seems to be fatal to your role in a call center. And so, as I've said a bunch of times today, I think your solution is an amicable one. I think if you can figure out a way with your employer to be transferred to a new role, that solves all of the problems, right? I also don't know medically what happens to you if you go back to your call center role. How damaging that is it a non-starter medically? Is it something that you can cope with for a while you continue to look? I think these are complicated questions. And again, and I think I said this earlier to you, but when you're talking about medical accommodation where you get it wrong and you lose your job and you lose your severance, you get it right, you continue to work. Like, these are really naughty, hard problems. I recommend you talk to an employment lawyer. So I'm going to give the information to everyone one more time. If you want to get a hold of us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. So that's it. Thank you very much for your questions. Appreciate you seeing me in this alternate time slot. And I won't be here on Friday like normal, but I'll see you in about 2.5 weeks. Join us tomorrow with Lior. You don't want to miss that. Founder of our firm, Lior Samfiru, is going to be answering all your questions about all things employment law. It's going to be a great show. Don't miss it. Join us tomorrow for that. Otherwise, I'll see you in 2.5 weeks. Thank you for your wonderful questions.